Ready? Start. The disputes between the parties relate to lands measuring 37 canals, 5 marlas as comprised in several survey numbers forming the subject matter of OWP number 480 of 2003 and OWP number 455 of 2005. On 21st November 1980, the custodian of evacuee property, Kashmir, issued a notification under Section 6 of the Jammu and Kashmir State Evacuees Administration of Property Act 2006, hereinafter referred to as the 2006 Act, declaring the aforesaid land to be evacuee property, being in the ownership of one Kamar Uddin and other evacuees, in as much as the writ petitioners in OWP number 480 of 2003 claiming to the tenants at will of the land involved in the writ petition commenced earth filling, they were stopped from doing so by the evacuee department. It is the case of the writ petitioners that when they made inquiries, they were able to lay their hands on records indicating that the lands measuring 11 canals, 6 marlas out of the land comprised in the said survey numbers had been taken over by the evacuee department and placed at the Supurdnama of the custodian while three seizure memos dated 22nd January 2003 and 1st February 2003, claiming that they were in possession of the land in the capacity of tenants at will since before the aforesaid act came to be enacted. The petitioner in OWP number 480 of 2003 prayed for the following reliefs. It be declared that Section 6 of the Jammu and Kashmir Evacuee Administration of Property Act 2006 is unconstitutional. It be declared that Section 3 of the Agrarian Reforms Act 1976, in so far as it excludes the application of Sections 4 and 8 of the Tenants of Evacuee Land, is ultra vires the Constitution. That by an appropriate writ, direction, or order, including the writ in the nature of certiorari, following notification, communication, bequeathed. That by an appropriate writ, direction, or order, including a writ in the nature of prohibition, respondents be restrained from interfering in the rights of possession of the petitioners in the land and in their leveling of land and from fencing. Along with the writ petition, the petitioners also filed a miscellaneous petition seeking interim relief in which it was ordered that the respondents were not to dispossess the petitioners from the lands in dispute till the next date. The petitioners were also restrained from raising any construction or changing the nature and character of the said lands during the said period. However, when during the pendency of the writ petition the custodian started construction of a shopping complex in violation of the said order of injunction, the petitioners filed another CMP in which notice was issued on 22nd April 2004, returnable within 4 weeks, and till then the parties were directed to maintain status quo. Subsequently, by an order dated 30th September 2004, the Registrar Judicial of the High Court was appointed as Commissioner to visit and submit a report, which he did on 7th October 2004. On receipt of the report and on being satisfied that construction work had been undertaken by the custodian on the aforesaid lands and was being proceeded with, the High Court by its order dated 19th November 2004 restrained the respondents from raising any construction on the spot, since its earlier orders had been violated by the custodian. The station house officer of the concerned police station was directed to see that the order of the court was duly complied with till the petition was considered for admission or until further orders. Aggrieved by the aforesaid order of the learned civil judge, the custodian of evacuee property filed LPA number 169 of 2004. Other writ petitioners who also claimed to be in possession of their lands as tenants at will and as protected tenants have also challenged the validity of the provisions of Section 6 of the Jammu and Kashmir Evacuee Administration of Property Act 2006 and Section 3 of the Agrarian Reforms Act 1976 insofar as it excludes the application of sections 4 and 8 to the tenants of evacuee properties stock.